SwayamPrabha. Digital India. Educated India.
Welcome to the lecture number 15 of the course on law of torts, consumer protection and motor vehicles. Now, this is the last lecture on law of torts. After this lecture, we will discuss consumer protection and motor vehicles, which are two allied parts of this torts and which deals with what we call statutory torts. Now, in this lecture, what we will largely cover is the questions relating to remedies. Now, tort is a subject which deals with civil wrongs. We have seen that various types of wrongs that are considered within the domain of tort. Now, when wrongs happen, then of course the persons come to court of law for seeking remedies. So, therefore, up till now we have largely discussed the various types of wrongs involving torts, and then how do you discharge your defense in connection to defendant side. In some cases we have also seen the type of prayers that you can make, but now broadly we are in a last stage where we discuss that how do you what remedies that can be pleaded in a tort action, and what are the ways in which tort liability is discharged. Now, what we mean in dischargement in law is that when somebody incurs a liability and which is a legal liability, then there is a legal way to discharge it. You cannot just forget it and sleep over it and it gets discharged. Of course, it can get discharged over time through limitation, but that way it cannot happen usually other than limitation bar. So, there is a process by which dischargement happens. So, in this particular lecture, we will discuss the various remedies available in law of torts and the ways you discharge the tort. In this lecture, we will cover these 5 important topics. First, types of remedies for tortious liabilities. Second, among these various types of remedies that are available, the most popular and common form of remedy is damages, that is by way of compensation. So, what are the principles that the courts should follow at the time of awarding damages when liability is proved with reference to a tort action? Then in damages there are various therefore various principles that are followed in order to determine damages, and one of them is foreseeability, which is a very important aspect. And what is and how do you establish the foreseeability of the wrong? And then there is a rule of novus actus intervenus, which means that the chain of tortious events must not be snapped. The chain of tortious events must not be snapped. If the chain of tortious events gets snapped, then there is no liability. The liability breaks. This is called the novus actus intervenus principle. And finally, we will end up by discussing how do you discharge torts. So, let us start with the question of what types of remedies are available for tortious liability. Largely, when we look at the types of remedies, there are 2 broad heads in which remedies can be divided. The first type of heads are called judicial remedies. By the very way of using the term judicial, it means that these remedies can be only availed by the plaintiff by approaching to the court of law. So, the court of law only can award these remedies, and that is why it is called judicial remedies. In addition, there is another type of remedies which are called extrajudicial remedies. Now, these extrajudicial remedies are not something that you can seek from court of law. usually extrajudicial remedies are called in the nature of self-help, and the person resorting to them may frequently exceed their rights and take law in their own hands. So, usually it is better that extrajudicial remedies are not availed as far as possible, and as far as possible remedies which are available through the judicial nature are proceeded, because there are many issues that can emerge in extrajudicial remedy. There are some cases, for example trespass. Now, in trespass there is a extrajudicial remedy, that is expulsion of the trespasser. So, if somebody has entered into property without a lawful consent of you, then he is called a trespasser. Now, when a trespasser has entered, you can by forcibly or by other ways can expel him from your property. Now, when you use force, sometime which may happen that the force you use is more than what is expected or proportional, and then in that case you may become a instead of a victim of a tortious wrong, a offender or a accused or a defendant. We saw in our discussion on general exceptions, in the case where Bird versus Holbrook, where a small child for the purpose of catching a stray fowl entered into somebody's land without a consent, so he was a trespasser. But in order to prevent trespassers to enter his house without any kind of providing information, the owner of the land had used something called a spring gun, and these are very dangerous kind of instruments, and the child by somehow unfortunately placing his leg on the spring gun was exposed to its fatal effect, and the child was injured very severely. And then when the question came, and when the defendant in that case pleaded that the plaintiff is a wrongdoer because he has trespassed into my property without my consent, the court said we could have accepted and we could have allowed this justification if your action was proportionate to this wrong. Now, for the protection of your property, which is largely a residential property, there is nothing like a very secret or confidential or hazardous thing is happening. Now, you cannot place disproportionate amount of security measures. Now, what you can do is that you can put some nails or glass on your boundary walls, you can put some barbed wires, you can put some other nominal ways to prevent from others to trespass into your property. But when you put something like a spring gun which is so dangerous, then that is not proportionate. And that is why the Bird versus Holbrook case, the defendant did not got the benefit of the justification of the plaintiff as a wrongdoer. Rather, he was considered to be a wrongdoer in this case, because there was no proportion in the force. So, therefore, when you use these self-help measures, there are all possibilities that you are taking the law in your own hand and you may run into trouble. So, the best is to avail judicial remedies. Now, among the available judicial remedies for law of torts, there are three major types of remedies that are usually given by the courts in case of when there is a liability on the defendant proved by the plaintiff. Now, these are first and the most popular or most common is damages, or what we can say also compensation. These are basically pecuniary compensation awarded to the plaintiff for the injury or damage caused to him by wrongful act of the defendant. Now, damages can be substantial or damages can be nominal. Nominal is where the loss is very nominal. So, just to acknowledge that there has been an infringement of his legal right, a nominal damage is given by the court sometime. But when the loss is substantial and there is enough evidence, then full and substantial damage is provided. Sometime the act or the wrong is such that it affects society at large or public interest at large. So, in these cases courts intend to give punitive damages to ensure that in future, in fear of some punitive or exemplary damages, people are deterred from undertaking such kind of wrongs. So, damages is usually the most common and general form. Usually special damages are also provided in certain cases, but in tort cases special damages are not very common. So, nominal or substantial damage, general damages or nominal damages, these are exemplary damages, sometimes punitive damages, sometimes these are usually granted in generally tort cases. Followed by these damages, the second type of judicial remedies that is provided by the court is called injunction. Now, injunction is a measure to ensure status quo. So, there is a dispute between two neighbors about a piece of land, and one person wants to build a wall and the other person is saying that your wall that you are constructing, part of it is actually entering into my property, which is illegal, and therefore you are a trespasser. Now, therefore, this requires a factual determination, and factual determination cannot happen without evidentiary process and trial, and it will take time. But if by that time the wall is constructed, it may cause loss to any of the side who is ultimately declared by the court after end of the process as rightful, and the other person is wrongful in terms of their act. Now, if the person who wants to build the wall, now he is declared as his construction of wall was actually a trespass to the other person's land or property, then he has to take it down. So, this entire cost of building the wall is wastage. So, therefore, in such cases what the court is generally providing is a status quo order and injunction that do not do anything beyond this. Now, injunctions can be in the form of temporary, injunctions can be in the form of permanent also, right. In nuisance cases, permanent injunctions are provided. For example, a factory which is located in a populous residential area which is emitting carbon dust, which may not be in itself hazardous to health, but it accumulates over houses, trees with the black color, and it disfigures. So, it is very, very obnoxious in terms of its look, and sometimes it gives bad foul smell also. So, therefore, the company the court passes a permanent injunction for the company to stop production until and unless they bring measures to control the exposure of the carbon particles which is currently causing the nuisance. So, there can be a permanent injunction also. Closure can be an order through permanent injunction. And the third one is called specific restitution of property. What this means is that when somebody has wrongfully disposed of somebody from his rightful use of immovable property or a specific movable property in question, then court may order that the property is entitled to recover the immovable or the movable property, as the case may be, restitution, to bring back to the earlier stage as it was his rights. So, therefore, specific restitution of property is the third judicial kind of remedies that are possible in case of torts. And injunction and specific restitution of property though exist, but the most common form of remedy that is pleaded and that is usually given in case of tort cases is damages. Here injunction is given, where specific restitution is given, there also claims for damages are always there. So, in this lecture we will discuss damages in details. About injunction and specific restitution of property, we are not going into any further detail. It is a form we can just understand, it is a form of judicial remedy. One is to restrain the commission, perpetration or continuance of a wrongful act, and specific restitution of property is when a person is wrongfully disposed of immovable property or a specific movable property, is entitled to recover the immovable property or the movable property, as the case may be, through the order of specific restitution. But we will discuss in details now damages. Now, when the question of damages arise, court is usually faced with these three broad questions in order to determine. The first question is that the damage alleged by the plaintiff is due to a wrongful act of the defendant. So, there is a causal link between the defendant's wrongful act and the damage caused to the plaintiff. What does this mean? This means that I pushed him from the back and he fell down and he was injured. So, my pushing from the back with an intention was his cause for falling down, and due to falling down he has incurred these injuries. So, therefore, I am liable. So, that is the causal link. So, therefore, the first thing that in case of determining damages, the court has to examine and the court has to establish is the causal link between the defendant's wrongful act and the damage claimed or alleged by the plaintiff. Now, once this is established, the second step that is to be undertaken is that, okay, I understand the damage was caused by the plaintiff, by the defendant, but was it foreseeable by the defendant? Now, in this case, let us imagine a scenario. Now, say this is a railway station, this is a platform, this is the rail line passing by. Excuse me, I am not a very good artist. So, not even a very good, I am not at all an artist. So, I am very trying to crudely describe you through this pictorial representation. This is platform number 1, this is platform number 2, platform number 1 rails are on both sides. And platform number 2 there is only one side rail and this side there is a wall, boundary wall. Okay. Now, one train was standing in platform number 1. And after the scheduled time for its departure, it started slowly moving and picking up its motion, but it was still not in high speed, it was just picking up its motion and it was moving towards this direction. And the defendant in this case D, he was trying to catch this train, so he was running from this direction towards the train. In the last compartment, which is the last compartment of the train, which is the guards compartment. Now, 2 railway employees who were standing, seeing the defendant was running to catch the train, they extended their arm and the defendant hold one of the employees' arm and the employee snatched him into the compartment and he jumped into the compartment. Now, in this process, what happened was that he was carrying a small packet in his hand and that small packet fell from his hand in this motion of or jerk that he was snatched in. This packet fell and already the train has passed. So, there was this empty portion of the railway track where this box which was in the hand of the defendant now fall. Now, to the surprise of all, the box was consisting of some explosive substances or some normal firecrackers. It is better to say firecrackers. Now, when this box came into contact of this rail and due to friction, when a train leaves, due to friction the rail for some time are very heated. So, when the box came in contact with this heated rail line, what happened was there was an explosion. Now, due to this explosion, one portion, so there was a pillar here in the platform and the pillar had tiles. due to this explosion happening here, explosion that happened here, if you say this is the explosion site, due to this explosion, now one tile in this pillar chipped out, and in a projectile motion it went to this direction, and the plaintiff standing at this direction, which is at least not less than 75 meters away. So, this distance between plaintiff and from where this tile was chipped out was at least 75 meters. This distance was 75 meters. It hit the plaintiff and the plaintiff got seriously injured in his face. Now, the question is, first, causal link. Yes, of course, the defendant was carrying the box fell from his hand, the box contained firearms, contained explosive substances, firecrackers. The firecrackers coming in contact of the hot plates of the railway line exploded. The explosion caused these tiles to chip out and flow in the projectile motion. But so there was a causal link. So as far as causal link, it was satisfied. But the second question is, can the plaintiff possibly ever foresee such a situation that somebody standing at this distance, because of his firecracker in the box exploding, this tile chipping, cause damage? So the next question is, how remote is the cause of the damage? Now, as remote it is, it will be less foreseeable. Less remote, so more remote, less foreseeable, less remote, more foreseeable. So therefore, remoteness and foreseeability, that is the second thing that the court has to examine when at the time of granting damages. And the third important is that after this, pecuniary calculation of damage. Calculation of damage or computation of damage. Now, damages can be for three types: personal injury, death or loss of property. Now, in case of loss of property, it is easier because you can find out what is the substantial value of the property and put some depreciation or whatever related other aspects and you can award. But for personal injury or death, computation in terms of money is very, very difficult. Now, we will not touch upon this issue much in details. When we discuss the last lecture in this course, we will discuss personal injury and death of persons, how damages are computed in case of motor accident. The same formula or the same principle applies for any type of tort cases where death or personal injury happens. 99% that is the same. So therefore, these are the three important aspects: causal link, remoteness and calculation of damages. I will need this today several times because there are few examples where it is better if I give a pictorial representation, with my caveat that I am an extremely bad person with pen drawings as concerned. Okay. Now, I go back to the slide. So, therefore, these three important aspects are very, very connected and important for determining damages: alleged cause or link, what is was it too remote, so the remoteness which leads to the question of forcibility, and third is monetary compensation for the damage. Now, we will start with the causal link, or which we call causation. Okay. Now, generally to figure out causation, courts have initially started using a test called but for. So that means the damage is caused due to this. So but for. So it is for that act, but for that act that the damage has only been caused. So the first case where this but for test was applied or evolved was in the case of Robinson versus Post Office 1974. Now the facts of this case is the plaintiff who was a post office employee slipped while descending a ladder, and the ladder had become slippery due to the negligence of the employer. The plaintiff sustained a wound on his left shin. So some 8 hours later he visited the doctor and was administered ATS, which is a medicine in form of injection, which is for the purpose of preventing any kind of possible major infection like tetanus. But there was a procedure available at that point of time for the purpose of injecting or administering this ATS injection, and the procedure was that you first apply a very small dose and wait for half an hour to see whether there is any reaction due to the injection. If after half an hour there is no reaction, then you administer the remaining whole dose and then you leave the person. But in this case, the doctor between the test dose and the main dose did not wait for the established protocol of half an hour. He, after administering the first dose, within 1 minute or 2 minutes again administered the full dose. But even after administering the full dose for next 3 days, this plaintiff Robinson did not show any kind of reaction. So there was no reaction. However, on the 4th day he had encephalitis. Now medical science at that time showed that one of the possible side effects of ATS can be encephalitis, but not always. So the courts therefore were faced with this question, that is this encephalitis which has happened in the plaintiff is a result of the negligence on the part of the doctor in administering the ATS dose. Now based on the available medical evidence at that point of time, the court said that in case if we presume that not fulfilling the standard protocol was a negligent act, but if there was a reaction of the injection, it would have definitely happened within 3 days. Now after 72 hours, if encephalitis has happened, that cannot be ascribed to the negligence or to the ATS side effect. So on this ground, the suit for the damages against the doctor was not found to be negligent. The reason that the court gave, I just now discussed, doctor's negligence lay in not waiting half an hour after the test dose, but the negligence did not cause the onset of encephalitis, for it was almost certain that when plaintiff did not show any reaction for the 3 days after administration of the full dose, he would not have shown any sign of reaction even the doctor had waited for half an hour after the test. So a kind of a very stiff rule was administered. So a very steep rule was administered in this case. Followed by that, the rule was again applied in another case where the question was that a widow of a workman who had suffered an injury from falling down a steel tower in course of his employment filed a suit against the employer. Now the negligence on the employer was quite apparent, because the employer did not provide it to any employee who was working on those tall steel towers with the necessary safety belts. But the employer's defense was that yes, it is accepted that on that day or generally we have not provided, but in the past we have seen with this particular employee that whenever the belt was made available also, he never had used it. So in all possibility, if on that day the belt was also there, he would have not used it. So the having the belt or not having the belt, or supplying the belt to the employees or not supplying the belt to the employees, does not make any difference in this case, because even if the belt was available, this particular gentleman would not have used this. Now, on this finding, it was held that the defendant was not in breach of any duty by not providing the safety belts, and hence they were not held to be liable. Now, this was again an extremely bad kind of a precedent, because in that case employers could have easily stepped out by showing this kind of arguments or this kind of defenses. The third case, however, shows a little kind of a departure from this approach of the but-for test, because the courts held that the but-for test A does not have a universal application, and the second is that but-for test, if is applied in such strict sense, will lead to injustices, and courts cannot when apparently seeing injustice, gross injustice being meted out because of its decision, can allow to happen that. Now, this was done in the case of Maggie versus National Coal Board in 1972. Now, in this case, the workman contracted dermatitis after some days spent in the cleaning of a brick kiln. Now, the employer was not in fault for the hot and dusty condition of the brick kilns, because they are generally like that. However, the employer was at the fault that it did not provide any washing facility in its site, consequence of which the employees had to cycle a long distance back to their home before they could wash themselves. So, in an unwashed manner, with all this dirt and filth that they get exposed to in the brick kiln, they had to cycle a long distance, and after reaching home only there is a possibility for cleaning themselves or taking a bath. Now, cycling is an act where your body fluids, sweats, etc. flow out, so that dirt, filth mixed with the body fluid can cause skin disease, but it cannot be said with 100% that that is enough to set a dermatitis, right. So, when this employee suffered from dermatitis and filed a suit for compensation, the defense that was taken by the employer is that yes, we have not provided the washing facility, but it cannot be said that this is the but for reason for the dermatitis that happened in that person. Now, court in this case held that it was found that of course, not always dermatitis can be caused because of this, but absence of washing material increases the risk of the disease. So, yes, it is not possible to conclude always with 100% inference that this is the cause of dermatitis, but there is sufficient medical evidence to show that if you are not cleaning yourself immediately coming out of a brick kiln, and then continue to carry with that dirt in your body and cycle and body fluids get mixed, you are at an increased risk to get the disease, and on that basis the defendant was held liable. This was decided by the House of Lords, and the reason that was given the House of Lords is that in the circumstances the but for test would have led to unfair result. The court said if we apply but for, as it is argued by the employer, it would lead to an unfair result, denying redress to the employee, and could not be departed from a lesser degree of causal connection. Namely, by material increasing the risk of disease, each employer had materially contributed to causing the employee disease. So, the court therefore gave here not a blanket not to but for, but understood that it does not have universal application, and there are limited situations where injustice is blatantly meted out in application of but for. The court are giving a direction to the courts below that they should depart from using the but for test. The next question in causal link is that if there is a case where a doctor has wrongly diagnosed, and the wrong diagnosis after that was detected, and then the treatment that was undergone was late, and that reduced the chances of recovery of the patient less compared to possibly if it was diagnosed at the initial stages, whether can be constituted as a negligent act leading to damage. Now, in Gregg versus Scott in 2005, House of Lords had this opportunity to consider this question in this case where the plaintiff had a lump under his arm which he showed to Dr. Scott, and Dr. Scott thought it's a collection of fatty tissue. But most likely the expulsion, but unfortunately this was the most likely explanation in such situation, but unfortunately it was wrong. The patient had cancer of a lymph gland which was discovered a year later. He was treated with chemotherapy and was still alive after 9 years when the appeal was heard. Now, Dr. Scott was found negligent in excluding the possibility that the growth might be cancerous. He should have referred the patient to a routine checkup in the hospital, which he could have settled the matter. But the patient, however, failed to prove on the balance of probability that Dr. Scott's negligence had affected the course of his illness or prospect of survival. This is most important. The patient's case here was that if Dr. Scott had initially made the diagnosis, then my course of illness could have been comparatively different and my prospect of survival could have increased. Now, there the court said that the patient fails to show with material evidence, and the patient's alternative submission that a loss of chance of favourable outcome should itself be recoverable head of damage in case of clinical negligence was negativated. The court held no, that cannot be a causal link. Now, the next case or the last case in this regard is if successive injuries happen on the same wound or the same kind of place, and the second injury turns the things even worse. Will the second injury reduce the liability of the first defendant? So, when events causing damage to the plaintiff are not simultaneous but successive, what happens with the defendant's liability? This was discussed in the case of Beaker versus Willow in 1969, again House of Lords, and in this case the plaintiff's leg was injured in 1964 when he was knocked down by a car which was negligently driven by the defendant. Now, when this case was under consideration and preparation for trial, in 67 the plaintiff was shot in the same leg in an armed robbery, during an armed robbery, and the limb had to be amputated well above the knee. Now, after this second incident happened, the defendant of the first case argued that no loss or injury suffered thereafter by the plaintiff could have attributed to his tort, since its effect was obliterated by the gunshot injury followed by the amputation. He said that my injury left him with the leg, maybe there was some permanent disablement or there was some case, but that now is irrelevant because he has now lost that knee, that leg because of the gunshot injury. So, therefore, my case becomes irrelevant. So, excuse me, don't put me on trial or don't ask me to pay any compensation. The court rejected this submission and allowed damages for both past and future. When the matter came to appeal before the House of Lords, the House of Lords restored the trial court's judgment and said that the supervening event has not made the plaintiff less lame or less disabled or less deprived of his amenities. He said that it's not that if this injury had not happened, he would have been like as he was before the car accident. So, the second injury has not left him in any less deprived of his amenities or disablement or his lameness which the first injury has done. Rather, it has now made him worst, more disabled, more deprived of amenities. Therefore, he should not have less damage, though being worse off that might have been expected. So, therefore, the first defendant cannot be excused or first defendant cannot say that now my case is not there and my case is rest. Rather, the first defendant is also required to pay damages as it is in general case. So, therefore, you can see that through this various but for test, which is a primary way, and then making necessary modification and amendments, the courts have usually established the causal connection between the defendant and the wrongful act and the loss caused to the plaintiff. Now, moving forward, as we showed in the very beginning in our example, that causal connection is not the only thing, it is a one of the element. Now, after you establish the causal connection, the next important test that comes is whether the damage that has been caused or the injury that has been suffered, was it too remote or it was not too remote. So, remoteness. Now, the concept of remoteness is usually meant as a person is therefore held responsible in law only for consequences which are not too remote. So, if it is too remote, as it was in our case, first example, then a person cannot be held responsible, but he can be only held responsible if it is not too remote. Okay? So, the foreseeability test of remoteness is usually applied, which means or which in the sense is understood as consequences are too remote if a reasonable man would not have foreseen them. So, those consequences which are too remote if a reasonable man could not have foreseen them is a remoteness, and there the damage claim fails. Now, this again a series of judgment has examined this rule and has come down with a proposition which is the law right now. The first case where this question was put before the court was in re polemis. The facts of the case was that there was a vessel, a sea vessel, which is containing a cargo of petroleum and benzene under the charterer. Charter is a form of a contract by which from the owner of the ship, a particular company hires the ship and then the ship is under his control. So, the charterer was under the control and he was carrying a cargo of benzene and petrol. Now, due to leakage in some of the barrels where this oil was or this substance was stored, there was a petroleum vapor that was formed in the hold of the ship. Now, that vapor had generated and accumulated and was lying there accumulated in the hold. Now, when there was a movement of the cargo, in that process the employees of the charterer misplaced one plank and that plank fell into the hold, and because it fell from some distance and the hold is also made of metal and this plank is also a metal, the two metals coming together in friction caused a spark, and from the spark the petroleum vapor which had accumulated in the hold ignited and it caused an explosion and fire and the whole vessel got destroyed. Now, in this case the owner of the vessel filed, the plaintiffs filed a case for compensation for the loss or damage to the vessel against the charterer who was a defendant. Now, the question was that was this event too remote for the employees or the servants of the charterer to foresee. Now, court answering this question said that yes, apparently it may happen that this whole event looks to be very remote, but you have to understand that the falling of the plank was due to the negligence of the employees of the charterer. That part is proved. Now, that negligence was the source of the subsequent events which led to the whole consequence. So, they are direct fallout. So, when there are direct fallout or direct consequences of this, then the charterer cannot escape. So, the rule that was propounded in this case is in connection to determining forcibility is that direct traceable negligent act, all the damages caused which are direct consequence of the traceable negligent act are foreseeable or are not remote, not remote, and therefore the defendant is liable. But this rule was subsequently disapproved by the Privy Council in the next case in 1961, which was Vaughan Morden. Now, this was also a case relating to ships. So, a ship called Vaughan Morden was standing in the berth of the Sydney harbour, and it was carrying also again same petrol cargo, and the petrol leaked from the hold and it was floating over the sea water. Petrol floats over sea water, and it spreaded over a substantial area, including wharf. Wharf is place where ship repairing yards basically. So the wharf belonging to the plaintiff, the oil entered into through the water into the wharf, and in the wharf there was another ship which belonged to another company which was under repairing. Now in the repairing process, by some drop of molten metal from the welding operations that were conducted, ignited the petrol floating on the water, and it alighted a big fire which completely destroyed the wharf of the defendant and also the ship which was standing for repairing. Now in this case, the simple question was whether the defendant can be held liable. The trial court, using the re-polemist formula of direct consequences, clearly said that it may not be foreseeable from the beginning, but it is definitely a direct consequence, and hence they have to be held liable under the re-polemist rule. But in the appeal in Privy Council, the trial court judgment was reversed, and the appeal court held that polemist case should not be regarded as a good law, for it does not seem consonant with the current idea of justice or morality, that for an act of negligence, however slight or venial, which result in some trivial forcible damage, the actor should be liable for all consequences, however unforeseeable and however grave, so long as they can be linked as a direct effect. So this direct consequence rule that was devised by the re-polemist was reversed or was held to be not applicable in the Vaughan Mordaunt case. So Vaughan Mordaunt said, here it is again reasonable foreseeability, what you can foresee at that point, not like all the other things which are also direct consequences, right. But the interesting point is that this judgment of Vaughan Mordaunt 1 in 61 underwent a modification in 66 in the same Vaughan Mordaunt 2. Now in Vaughan Mordaunt 2, the case was between the same defendant Vaughan Mordaunt, but a different plaintiff. In this case, the plaintiff was the ship which was there in the wharf for repairing and which was damaged or engulfed by the fire. So the owner of the ship filed a case against Vaughan Mordaunt for recovery of damages. Now in that case, the court, however, did not accept either re-polemist or Vaughan Mordaunt 1, because according to the court, what it says that when it comes to foreseeability, if a real risk is one which would occur to the mind of a reasonable man and which he would not brush aside as far-fetched, if the criteria is to be what the reasonable man would have done in circumstances, then surely he would not neglect such a risk if the action to eliminate it presented no difficulty, involved in disadvantage and required no expenses. So what the court is saying, that if there is a real risk because of the negligence act and the risk cannot be brushed aside, that it may have some very severe consequences, and if the cause of the risk could be avoided by some very nominal thing, then in that case not taking action makes them liable. And the court held here Vaughan Mordaunt liable in the Vaughan Mordaunt 2 against the defendant ship owner on these 5 grounds by applying this rule. What are the 5 grounds? The finding that damage of fire was foreseeable because of the following reasons. 1. There was a real risk of fire, though remote, because of the leakage of the petrol and petrol floating over the sea water. The risk was great if the oil caught fire, serious damages to ships, because there were many ships and other features around that area. A qualified chief engineer of the defendant, that is Vaughan Mordaunt, would have known the gravity of the risk. So action to eliminate the risk presented also no very big difficulty. So in that case, a reasonable man in the position of chief engineer would have realized, foreseen and prevented the risk, which he failed to take, and hence they are liable. So you can see from re-polemist to Vaughan Mordaunt 3 in the 50 years period how foreseeability test has evolved. So now the foreseeability test which is usually used is what Wagon Mount 2 has involved. Wagon Mount 2 has created, which is if there is a real risk and that real risk cannot be avoided by any reasonable man and cannot be brushed aside, and the factors of the risk can be eliminated, then in that case, if not it is done, it is considered to be foreseeable. Now moving to the next, which is break of chain of circumstances, or what is called novus actus intervenus. Now damages resulting to the plaintiff after a chain of causation set in motion by the defendant's wrongful act is snapped or too remote if it qualify for award or damages against the defendant. So basically, when we see the remoteness or the causal link, novus actus intervenus is a linking point between both. So when we are trying to establish the causal link, we have to see that whether there was any break or some kind of a stoppage or an intervention which caused the chain of circumstances or the chain of connection between the two set of parties, the plaintiff and defendant, break. So, third party intervention, that is called novus actus intervenus. Now, an example of this application of novus actus intervenus is the case that is stated in the slide, where a minibus belonging to the defendant company at the end of the shift was parked by its driver in a regular spot of the company and the ignition key left in the bus. Now, a third party entered, stole with the intention to stole the bus, put the ignition key and drove the bus away, but because he was not able to steer the bus properly, he met an accident in which the defendant's wife was killed. Now the question was, the plaintiff's wife was killed. Now the question was, is the bus company defendant liable? The court held no. If the bus subsequently left in an unguarded manner, negligently accepted, would have been driven by employee of the company or by any third person with no bad intention, or any member of the company with whatever intention, it would have not broken. But here a third person intervention with an intention to steal, and because it was parked in its normal place, in a normal shift, this is a normal course of probably the chain of action that the shift change happens, you cannot say that it is wrong, and hence there was this third party's intervention breaking the link, which is called breaking the chain of circumstances. And now I move to the last topic of discussion, which is dischargement of torts. Now as I said, as you incur tort liability by a wrongful act, you have to discharge it also legally. So there are 5 ways by which dischargement of torts can happen. First is actionio personalis motor cum personal. Now this is an old common law doctrine which means that death discharges tort. Earlier this was applicable, but now this has been modified. So this principle is not applicable, and we will discuss this in details in our lecture relating to motor vehicles. Next is waiver and acquiescence. When plaintiff forgets or does not take action, then his cause of action is considered to be waived. So intentionally he gives away his legal right. So that gives an acquiescence or estoppel for later on filing such a case. Accord and satisfaction is a kind of a settlement. So by a settlement he has accepted and he has been satisfied. Lastly, judgment recovered. Judgment recovered means where the matter has disposed by the court and court has given a discharge, court has given a judgment whether plaintiff is liable to pay compensation or he has discharged. So that is the dischargement. And last is the limitation statute. So there is limitation for every cause of action. No cause of action is for eternity. So every cause of action in tort has limitation. So if the limitation period crosses, then in that case the plaintiff is discharged. So these are the 5 ways by which dischargement of tort can happen. So thank you very much for paying attention, and we will meet in our next lecture, which is lecture number 16. Till then, thank you.